Okay, good morning, everybody. Call the meeting to order and first item, and welcome everybody. The first item of business is the approval of minutes from June 13, I'm sorry. Take my glasses off to be able to read.
I'll make the motion.
Second? Okay, all in favor? Those are approved. The next item is the budget request for fiscal year 26-27, and Burton and Patricia are going to present that.
I'll start. Sort of a level set. Less than 4 months ago in June, we were all here to talk about how to allocate the appropriation for the current budget year, fiscal year 25-26. And less than 4 months later, we're back once again to talk about budget, but this conversation is about our proposed budget request for fiscal year 26-27. So these ongoing conversations about budget is testament to the fact that in Albany, it's always budget season. But it's helpful to give you some context as you think about our proposed budget request, so that you can understand it a little bit better and understand our goals for this budget request. So in October, the budget director issues a letter to all of the heads of state agencies, providing them a deadline for submitting their budget request to the Division of Budget. And it's usually at the end of October. Euphemistically referred to as the call letter, this letter typically sets forth the governor's budget priorities in thematic ways, and then any limitations on what state agencies can request in their budget request. So for example, the letter may say that the governor's priority is a balanced budget and state agencies should not request more than a 2% increase from the current approved budget. Or if there's an anticipated budget crisis or shortfall, the call letter may say that the budget request has to keep funding flat or even reduce funding. The ILS board, so even though I get the call letter from the director of budget, I actually answer to this board and this board's decision about our proposed budget request. And in making this decision, the ILS office and this board are guided by Executive Law 832 and 833, which require you to submit a budget request that works to improve the quality of public defense. And that's both defense criminal matters and family court matters. But our budget request isn't enacted as requested. It never is. It goes to the governor. The governor proposes, submits to the legislature her proposed budget. The legislature goes back and forth with the governor, and there's a final enacted budget. So the reality is even though we have our statutory obligation and our statutory imperative, if there's a likelihood for our budget to be passed, we must be mindful of the current fiscal context in New York State, right? And so for this budget year, because of what's happening with federal decisions about budgeting, and because of a projected shortfall for the New York State budget, Burton and I had lots of conversations about how we could thread that needle between maintaining and honoring our statutory obligation to ensure that we're working and having the funding, the state funding available to improve the quality of public defense, but also being realistic about what's possible. And I really believe that our proposed budget threads that needle very well. And I credit Burton for his creativity and thoughtfulness in thinking through how we could do this. How do we do this? Burton's going to explain it in more details because I've asked him to really walk through our proposed budget request. But in thinking about it, I sort of want to take a step back and remind people that our budget request is basically includes will be two pieces of legislation, right? Our state operations budget, which runs our office, is the budget needed to run our office. And then our aid to localities budget, which is the funding that we disperse to counties. And so we think we've threaded the needle and fully honored our statutory obligation and mission, yet still been realistic by continuing, designing a budget request that continues to use the unspent previously appropriated funding in our 8 localities funding, and also being very prudent and thoughtful about any additional staff that we're requesting. Our imperatives in terms of any increased funding is 1, increased funding for improved quality family court representation, and 2, a slight increase to our state operations budget so that we can give or request salary increases for staff who have tenureship at ILS. So those are our imperatives for any increases. And the other thing we think that our budget request allows us to do is to save our ammunition, if you will, for those imperatives, to fight for those imperatives. So with that, I'm going to turn it over to Burton.
Yeah, thank you, Patricia. So in total, the all funds total of our budget request this year is $507 million, which is an increase over the current budget year of $16.6 million. So that's about a 3.4% increase overall. Patricia talked about the 2 sort of buckets that our funding falls into, the state operations and 8 localities. For state operations, we're seeking $9.2 million. That's an increase of $650,000. As Patricia mentioned, that increase is attributable to a few things. Our anticipated full staffing pattern, longevity-based salary increases, and then a higher than the current year projected anticipated indirect infringement costs. We are going to be requesting the creation of 2 new positions, but that will not impact our state operations budget, and I'll talk about that in a few minutes. Second is our 8 localities funding, the funding that goes from ILS to the counties in New York City for programmatic purposes. There we are requesting $498 million, which is an increase of $16 million. So I'll start by going through the 8 localities programs, similar to what I did in the June meeting. We talked through the allocation plan. I'll start with the Indigent Legal Services Program. This is the program that funds ILS distribution contracts, as well as our Regional Immigration Assistance Center grants, and has also over the years funded several other grants that started out competitive and are now treated as non-competitive grants. This is a program that can be used for both criminal and family court representation, so the full gamut of Article 18B public representation. For the Indigent Legal Services Program, we are seeking a total of $81.9 million. The simple explanation is that will not increase the amount of funding that we have available to disperse out of that program. We are seeking a slightly smaller appropriation than we received last year, because last year the ILS program included a dry appropriation of $9 million for potential federal Title IV funding. So a dry appropriation is authority to spend up to $9 million worth of funding that we don't actually have sort of in the bank, if you will, to spend. We are significantly adjusting that from it was $9.9 million. We are reducing that to just $900,000 for this upcoming budget year as a better reflection of what we think may be possible for us to claim in federal Title IV funding. So at the core of that, $81 million for distributions and other grants that are funded out of the ILS program. Because of the allocation plan that this board approved in June, despite the fact that we are not seeking any increase appropriations this coming year, ILS is going to still be able to meaningfully increase the distribution grant funding that we currently disperse to all of the counties in New York City. And that's because we are freeing up some of the funding in the ILS program, the Counsel at First Appearance grant, which is for criminal defense only. We are moving to a separate program that is similarly for criminal defense only. That's going to free up, again, a significant amount of funding within the ILS program giving counties in New York City more distribution funding, which also contains more flexibility in how it can be used. So it can be used for, again, both criminal defense as well as family court representation. The second program is our largest program, the Correll Herring Settlement Statewide Implementation Program. For that, the total appropriation that we are seeking is just under $274 million. Similarly, we are not seeking an increase in that program. And as Patricia alluded to, because of unspent reappropriated funding from this program from prior budget years, we are going to be able to continue at our current appropriation level while still increasing the awards on the current contracts. And we are very closely monitoring what we have available in reappropriations and think that we will be able to continue at current appropriation rates likely for the next several years by using some of that unspent previously appropriated funding from the first several years of the statewide implementation program getting off the ground. Third program is our Article 18B Family Court Representation Program. This is where we are seeking the increase that Patricia talked about. We are seeking, once again, a total of $50 million as part of a desired 3-year commitment to phase up to the $150 million annually that we've determined is necessary to bring New York's providers of Article 18B Family Court Representation into compliance with our caseload standards. As a reminder, we received $25 million in the final enacted budget for this current budget year. So we're seeking an additional $25 million to get us up to the 50. And finally, for the aid to localities programs, our assigned counsel rate increase reimbursement program, we are once again seeking the $92 million that has been appropriated in the last several years' budgets. And that's, same amount, no increase. And just to give folks a sense of the extent to which that funding is currently being tapped into, for the last full fiscal year for which we have claiming information, and that's with about 95% of county claims submitted, counties claimed $65 million of that funding in fiscal year 24-25. So the $92 million remains sufficient, we believe, to fully reimburse all 57 counties in New York City for the 50% of the increased assigned counsel rates. We do expect that that $65 million amount will continue to creep upwards. As we get the outstanding 5% of county claims that still need to be submitted, and then B, as the assigned counsel vouchers that are getting paid out are now closer to fully 100% at the higher rates. For some counties, they're still paying out some vouchers that contain work that was completed prior to the rate increase. So that is the summarization of our aid to localities budget. Turning now to the 2 new positions that we're seeking to create. So we are looking to fund these positions, not by increasing our state operations funding, but via a transfer of funding from our aid to localities budget, and specifically the HHS statewide program, to state operations. This is something that we have the ability to do by virtue of the appropriation language that's included for the HHS statewide implementation program in the budget. We currently fund several positions via this ability to transfer funding, including the operation of our statewide appellate support center, our Western New York Regional Support Center, and our data officers. So there are a few advantages to doing this. First of all, as Patricia mentioned, it's effectively budget neutral in that it will not require an increased amount of our appropriations. Both of the positions are related and go right to the heart of the purpose of the HHS statewide program. The other advantage is that if we go this route, the creation of these positions via the transfer of funding can theoretically happen sooner than if we were to fund new positions out of next year's enacted budget. We would not necessarily have to wait until the passage of next year's budget to take the steps necessary to create these positions. Again, we have the ability to do this and feel we are on solid fiscal grounds doing this because of the amount of unspent reappropriated funding we have from the HHS statewide implementation program. The two positions that we are seeking to create, the first is a public information officer. This position would really go to fill an agency function that to date has not gone filled by one specific person within our office. And given our agency's size and the scope of our responsibilities and the funding that we disperse, Patricia and I really felt it was time, and this was informed by conversations we've had with our staff, that there really is a need for having someone who is responsible for our agency's communications related needs. So we anticipate that this person would help us develop a strategic plan for external communications, field and respond to press inquiries, assist with FOIL requests, draft and issue press releases, monitor and circulate press clips that are related to our work and public defense in New York State, assist with intergovernmental outreach, and draft newsletters about our work for both internal and possibly external circulation. The second of the two positions that we would be seeking to create is a regional immigration assistance center coordinator. So since 2016, ILS has issued competitive grants to 5 counties in New York City to establish a statewide network of regional immigration support centers to ensure that defense attorneys have access to immigration law expertise that they need to provide immigration advisals to their non-citizen clients. We think that this position would help maximize the efficacy of the REACTs and provide coordinated operational and substantive support. This is a position that we anticipate would help coordinate resources for the REACTs, including case management systems, a centralized website. They would assist the REACTs in their data reporting requirements to ILS, provide substantive quality control of the work that the REACTs are doing to ensure consistency, accuracy, and overall quality in the advisals that they're giving, creating and maintaining practice-related resources and trainings for the REACT attorneys, and researching and circulating regular immigration case law updates. All of these functions are something that really spoke to us as a need for the REACTs, especially at this moment in time when the immigration landscape is shifting on an often day-to-day basis. And with the federal administration's accelerated efforts for deportation proceedings, including for non-citizens who otherwise did not feel to be themselves to be at risk of deportation, the work of the REACTs is more important than ever. We really want to ensure that we have that coordinator position in place to maximize their efficacy. So that is the summarization of the budget request. And Patricia and I are happy to take any questions that you have.
The 2 new positions are either intended to be attorney positions or they're both non-attorney?
The REACT coordinator position, we are anticipating would be an attorney because one of the core responsibilities of that position will be helping to do some of the quality control for the work that the REACTs are doing, as well as legal research on immigration law. The public information officer, we do not anticipate would be an attorney. Yes, Jen.
On that, is there a reason why the title doesn't include attorney? Like why? I just didn't,
Sure. For agency positions, titles, because we are not a civil service agency, all of our titles have both a civil service title and then a working title. Regional Immigration Assistance Center Coordinator would be the working title. The civil service title for this position, we're thinking would be an associate counsel. So it will be promoted as an associate counsel position.
I saw that, it just.
Yeah, I hear what you're saying, and I think that's right, that we need to make sure that the messaging of this is that it is.
The outward look, it says.
Yep, yeah, no, absolutely.
So Brittany, do you have a target for how much the increase on the HHS would be? The percentage increase in the funding?
In terms of what
Your
we're,
disbursements, yeah.
yeah. I'm sorry, so for what we would be using for these positions?
No, I'm not on the positions at all. I'm on the HHS funding itself, because I think you said that we'd be able to increase the disbursement.
Oh, sure.
And I think, you'd indicated 9% for the ILS programs. But
Yes.
there was no indication of what the percentage might be.
Got it. So we've already started to undertake some of these efforts on the current contracts, and it's roughly about 6%. That it's not quite across the board 6% for every county. We've the work that our criminal defense representation team is doing is assessing the needs of the counties and the provider offices. But overall, it's roughly 6% sort of across the board.
Great, thanks.
So in terms of what each county did, it's really driven by compliance with Executive Law 832-4.
Great.
Yeah.
All right, this actually requires a vote. Everybody ready to vote?
I'd make a motion to approve that.
Second.
Okay, all in favor? Anyone opposed? Great. Thank you.
Yes.
I'm so supposed to credit.
I have a question outside of the vote. When you say New York City counties, what do you mean by New York City? I mean, tell me
Sure.
what
So
you're talking about.
yeah, so we often refer to the 57 counties in New York City. And that's because under county law Article 18B, New York City is treated as one singular entity, even though it is, of course, made up of the 5 boroughs. It's treated as one entity for the purposes of administering public defense. So New York City is its own entity, and in addition to that, we have the other 57 counties.
Okay, thank you.
Yeah, of course.
So the next item is video conferencing for meetings, and I think Burton is going to lead us on that.
Yes, as a public body, the ILS board is subject to New York State's open meetings law, which generally requires that the business of the board be performed in an open and public manner, affording members of the public the opportunity to observe, attend, and listen to the deliberations and decisions that go into public policy. And that's why, for example, these meetings here at the New York City Bar Association are open to the public, and there have been instances where members of the public have joined us physically for these meetings. Additionally, we do go above and beyond and offer via WebEx the ability to have members of the public watch the proceedings as they are happening. The open meetings law also governs the ability for public bodies to conduct their meetings using video conferencing, meaning the participation by members of the public body in the meetings using video conferencing. So for board members to count towards quorum and vote on actions taken by the board is required under a law that was enacted in the last couple of years to adopt a resolution allowing for the use of video conferencing as well as a set of procedures for its use. So before you is a draft resolution and set of procedures for your consideration. In sum, once this is passed, board members can start to participate in these meetings officially via video conferencing under either of the following circumstances. So the first circumstance is from a publicly accessible location other than here at the Bar Center, that the public is notified about at least 72 hours in advance of the meeting. We do anticipate that we will start to regularly provide notice that our Western New York Regional Support Center conference room in our Buffalo office is such a publicly accessible location. Even if no board members are participating from the Buffalo office, we will have it open and available to the public to view the meeting from there via the streaming video. And members that participate via video conferencing from a publicly accessible location will count towards quorum and can vote on actions. I should note, while we anticipate that we will regularly start to provide notice that the Buffalo office is a publicly accessible location, if circumstances arose where, and I'm going to pick on Chris as just an example, if you knew that you could not make it, but you had space in Ontario County that we could advise as being publicly accessible, that the public could attend with enough advance notice, you could participate from Ontario County, again, as long as the space was open to the public and we advise it as such. The second circumstance under which members would be able to participate via video conferencing, once we've adopted this, is from a private, non-publicly accessible location only under extraordinary circumstances. And that is defined in statute as disability, illness, caregiving responsibilities, and or any other significant or unexpected factor or event which precludes the member's physical attendance at one of the designated publicly accessible locations. In such cases, the board member has to notify the ILS director no later than 4 business days prior to the scheduled meeting, so that proper notice can be given to the public that that will be occurring. Members that participate via a private location, importantly, do not count towards quorum under the law. However, as long as there is a quorum of people physically present in a publicly accessible location, the members that participate from a private location do count towards votes, but not establishing the quorum. There are several other details about the meeting notices, website information, copies of the video I won't go into, that will fall on Mindy and I to ensure that we are complying with those, and we will be on top of that. And so that sort of summarizes it. The other thing I just want to note is that this meeting today does constitute a public hearing for the purposes of the requirements of open meetings law, which is section 103A of the Public Officers Law. We did solicit comments from the public for the past 2.5 weeks on the draft resolution and guidelines. We did not receive any comments from the public. Therefore, I have no feedback to provide other than any questions or feedback that you may have.
So what happens if an extraordinary circumstance arises a day before the meeting?
So
Like a blizzard.
Blizzard, I was thinking.
under the statutes, they just do not participate in the meeting.
I will,
Participate, sorry, meaning they can't even tune in from home?
They can tune in from home. They would not count towards quorum and could not technically vote as part of an action.
And would they be able to participate in the sense of commenting?
Yes, they could comment, yes.
We've implemented it slightly differently at the local level, where because of that concern, where true extraordinary circumstances really can't be planned 4 days in advance. That's been our approach. We give the chairman of the body, or in this case, either chief judge or Patricia, the ability to grant extraordinary circumstances. And then I think, I would have to double check this, but I think our clerks have put boilerplate in all our public notices that members may be participating remotely in extraordinary circumstances, so that it's always noticed that way, and then we don't always utilize it. That's, I think, how we've gotten around that. Don't know if that's legal or not.
If that was something that the board was interested in appending to this resolution and guidelines, that's something we could certainly consider.
I think it would be worth looking at what you've done. I don't know if there's anyone else we can see what they did, but there's an incongruity between extraordinary circumstances and 4-day notice.
Yeah. Agreed.
Again, there's a whole meeting without the quorum.
Yeah.
To talk about it, but don't without a quorum, how do you have a whole meeting?
Yeah.
Yeah, I will say, as I read the statute, I do think, Chris, the idea that if it's regularly part of the public advisal that members may be using, maybe video conferencing from a private location due to extraordinary circumstances, I mean, then you don't have to really worry about the 4-day notice if it's just part of the advisal.
If you're comfortable with that, then I would suggest we amend these. To indicate, we actually wouldn't even have to amend this, we really just have to put that into the public.
Yeah, that would just be part of our practice. Yeah, we can do that.
It's just a really small thing, which is under the results, it should be subject to the requirements.
Yep, we'll make that change too before finalizing this. Judge, did you have a question?
No, it's the same.
There's no further discussion, this requires a vote as well.
And we have a quorum?
In favor? Okay.
Yeah, enough.
All in favor? Opposed? Great, thank you. school board report in the investigation standards.
Actually start, promised Jen and Mandy that I would give a little bit of an overview of where we are at with these standards. So at a meeting last year, the co-chairs of our working group on determining standards for the investigation function of interdisciplinary defense teams made a presentation to this board about these standards. And they talked about the process that they're using for developing the standards, the fact that these will be first in the nation to have defense investigation standards, and the sort of guiding principles that they used and that the working group has used in developing these standards. And then, and one of the things that we talked about at that meeting, and I remember Kingston Faraday, who's one of the co-chairs on the working group, who couldn't be here today, talked about the fact that, when I approached him about developing standards for the investigation function of public defense teams, he was somewhat reluctant because he said, they're not at a place yet in New York where everybody could comply with these standards. But I talked to him about the fact that that's why we need standards, that standards serve as the North Star. They guide you in where you want to go. And while we're not there, because of the work that our office is doing and the funding we have from the state, we have the ability to start to go in the right direction. Let's establish that direction. And so that's, what started the idea of doing this work. So the working group, I was so impressed and have been as I've observed what they've been doing, not just in what they've produced, but also the process that they use. A very principled process, a process with clear direction to every members about what the goals are and how to work together. They created a working group of investigators and attorneys from across the state. I know many of the people in this group, and they created a group of people with very diverse views. And yet they managed to build, agreement amongst the mission and the goals and true consensus on where we're at with the standards. At the last board meeting, we presented the board with the standards and asked the board to review the standards and send us comments. And we gave a deadline for comments, and we received some very, very powerful comments and very good comments. And so now where we're at with the board is, Jen and Mandy are going to give a quick overview of the sort of the types, not all the comments that we got, but sort of the types of comments we got. And then where we incorporated the comments, but also where we didn't incorporate the comments. And there's sort of two buckets of where we didn't incorporate the comments, and they'll explain why. And then if this board wants further discussion, we're open to further discussion. But if not, and if the board is ready to vote on the standards after having reviewed them, we can vote on them. We don't have to vote today, right? If this board, after the discussion, decides that they want more review, they want more time to review what we sent them last week, we can save the vote for December. But if we're ready to vote, it'd be great. So with that, I'm going to turn it over to, I think, Jen.
Yeah. So like Patricia said, we were really grateful for the feedback that we received from the board members. There was a lot of, very detailed, helpful information, and we incorporated a significant amount of the comments and edits. And the version that was sent to you all today that you have has highlights throughout the document, and those highlights show the changes that we made from the original version that you had to the updated version, and how we tried to incorporate everyone's comments. And we also provided a very brief summary sheet that goes over, an overview of the comments that we received. But like Patricia said, there were some comments and feedback that we did not incorporate, and that was for really mainly two reasons. One of them was that some of the comments that we got were very detailed about the nuts and bolts work of investigation. And, you know, Mandy and I were talking even when we started doing this and drafting it, we had some commentary that was just like a how-to manual, 3 pages on conducting field investigations. And when we took a step back, we're like, that's not the real purpose of these standards. The purpose is to set the standard for these types of investigations, and then all of the information really on the nuts and bolts and how to, we're keeping that sort of an aside in separate documents to be able to put together further resources that are more how-to manuals and for trainings on really how to conduct quality investigation. And then the second category of feedback that, you know, we didn't fully incorporate was we got some questions about how these standards were going to be implemented. And that again is something that, as Patricia said, we want these standards to be the North Star on, you know, where people should be trying to get to. And then it's our work to be really working with the counties and meeting them where they're at and understanding where they're at and working with them to, you know who their investigators are, who their providers are, and figuring out strategies to help them implement the standards and be taking steps to get everybody to where we want them to be. So, you know, once we have the standards in place, you know, we want to reach back out to the working group because we talked about implementing the standards with them. And as practitioners, they had a lot of very good ideas. We want to talk internally about what sort of trainings we can put together, or how we can best create networks of investigators across the state to really begin taking steps to implement these standards. So that's really it. If anybody has any questions.
Do you have a process that you're thinking about, this isn't about the actual standard, but about keeping them sort of up to date in terms of the working group continuing to work? Technology changes when next year all of us are done.
All judicial decisions.
I mean, I think it's, you know, incumbent on us to be reviewing the standards periodically, reaching out to the working group members, staying on top of developing technology. We did try generally to make the standards sort of big picture enough that hopefully they will, you know, bend with the times as well. But, you know, if things happen and we need to revisit them, we're definitely open to that.
And I would just add that we, you know, ILS does have a history of updating standards. And so because I'm, you know, in the statewide appellate support center, I can speak to the appellate standards that were revised. And to the extent that I think we want to do an overhaul or a really closer look at these standards, I think we could definitely get the members of the working group who are interested and available back together to do that. We could even add new investigators, hopefully, to a new working group. But I do think it's, you know, we all, I think it's important to sort of keep an eye on that to make sure, to the extent that anything becomes less relevant, that we're updating it.
So, you know, short answer is we do anticipate that at some point the standards will be updated. I think in these standards in particular, because they are so new and so novel, not just in the state, but across the nation. And so when I think the work that we're doing in implementing will give us a lot of information about, one, when would be a good time to do it, two, what would be a good process to do it, and three, you know, what the updates should look like. So, you know, for example, we met before this meeting, we were talking about some of our other standards and looking at the possibility of doing updates for those standards based on the work that we've been doing with implementation.
I think it's terrific work. I really do. I think it's wonderful. And particularly impressed, as you've already mentioned, there really isn't a model for this. You know, the defense standards, the appellate standards, everything, you know, we had ABA models, things like that to look at. This is brand new, and I think likely probably see ABA or other groups, you know, SCLAD, you know, take off on this, and that would be wonderful, right? I wish I had sent this comment, so sorry about this, but the one question I did have, it's on page 19. It's under the ethical ones, number 6, with witness interviewed by attorney. And it says attorneys should not interview witnesses alone. And I just wondered if you could talk about that. I guess as an attorney and you know, my experience in mandated representation has been as assigned counsel, which I don't do anymore, but do it. But there were many times I interviewed witnesses alone. And I myself, I would look at this and say, well, the attorney should decide whether she or he thinks it's appropriate or a good practice in this particular case to do that. So it bothers me a little bit to have a standard saying the attorney shouldn't do this. But maybe I'm missing something.
You know, I think this was a point that our working group, I would say unanimously, all supported. And part of the reason behind it is that, you know, for so long, there weren't investigators available. People didn't have access to them. And so, you know, attorneys had to take it upon themselves to go out and do the investigation. But I think, unfortunately, that can create circumstances where you might make yourself a witness in the case. Because if somebody is telling you something and you're like, oh, this is so wonderful, I'm gonna use this on cross, or I'm gonna call them in, and then they say something opposite, you don't have someone to call in, you know, to finish your full impeachment of them and to take it to the next level and to verify for the jury or for the court that, you know, the person said what they originally told you. And so, you know, this standard was really derived from trying to ensure that, you know, all the information gathered through the course of defense will be able to be used to the fullest extent possible for the clients.
I have another reason too, and this is from my experience doing capital defense work. I was working on a case once and we were in a court appearance and the prosecution complained to the judge that I was telling witnesses, instructing witnesses not to talk to the prosecution, which wasn't true. But, you know, the judge started to ask about it and I said, Judge, if you want to talk to my investigator who was there with me every single time, you will learn that that's not what I said.
Yeah.
And that put an end to the matter.
Yeah.
And that has come up before. I, you know, was talking to, was at a convening and one of the chief defenders in one of the public defender offices said that one of his attorneys was being prosecuted for the attorney's conduct with a witness. And I said, well, the attorney had an investigator there with him and he didn't. So it's also to, yeah.
I fully admit that there are many good reasons why in some cases, maybe in most cases,
Yeah.
it's a better idea to have someone there, but sometimes it's not. And I guess I'm looking at this and as an attorney, I look at it and say, well, why is the standard coming out saying I can't do what I think is a better practice? I may have the right touch with this particular witness.
Right.
I need to have a conversation with them and you know.
I agree with that, but does it have to be alone? Because I also agree that attorneys should, you know, should make the decision about who goes to interview.
We just add some language like when possible or when feasible or.
Well, it already says should, it doesn't say must, so.
It must, but I guess the language that's bothered me, attorneys should not interview this alone.
Or if there were absent exceptional circumstances, because.
In my practice, even if, and I do a lot of indigent work, but I don't ever meet with a witness without somebody there. But I prepare those witnesses for that. And when I always lead the interviews, almost every single time. But I think they have to be prepared, especially to have someone there. I mean, I think primarily it's the reason that what if that witness takes the stand for the prosecution or takes the stand for you and says something else? You have no one to counter that if they deny saying something to you that could be material, that you have no way to counter it and otherwise can cross, then you can call your investigator or your
But this,
paralegal.
who the witness is, what if it's a friendly witness? What if it's the defendant's spouse?
Friendly today, not friendly. That's where it comes up, where they're very friendly now, and then trial happens, and then all of a sudden, wait a minute, what's going on?
And there are times in my practice over the years where judges had a great deal of enthusiasm for trying to remove defense attorneys or public defenders. And so this would be one of the kinds of things that they would use. Oh, well, you know, how are you going, now you've become a witness in the case and you have a conflict.
Prosecutors are often challenged in that way as well, if they meet with
Yes.
witnesses without investigator, they may become a witness and they're off the case. Or at least arguments are made that they should be off the case.
You know, say there were a few cardinal rules when it started years ago and with the Glade Society, and that was one of them. You never go to an interview with them. I just, you know, the way it's written seems to at least allow the attorney to make the choice, but to make it stronger than that, you know, I think attorneys too need that guidance to have it there.
Now, I can also see an opportunity where a witness calls you on the phone and then you know they've been hard to reach, they're going to disappear, and you might want to grab that opportunity. And so I think it should probably covers it, but if not, then maybe there is exceptional circumstances language.
I apologize in advance again, as the only layperson at the table on the severe disadvantage. Nothing on the content of the standards, but more to your earlier point about knowing that the counties are all over the place and that some won't be able to meet these standards or even in a position to make meaningful progress toward the standards. So I guess my question comes more on the implementation side, and specifically if the existence of the standards and how ILS chooses to try to implement them in any way exposes those counties that can't make rapid, meaningful progress toward the standards. Does that create a liability or vulnerability to those counties? So are we handing a weapon to the other side to be bludgeoned against the counties? Well, there's a standard out there that says you have to do this and you're unable to do this, and therefore we're going to get wrapped up with NICLU again, or whatever it may be. I guess that would be the question I have.
That's a good question. You know, our approach has always been, if you're a county that's not effectively using ILS funding and not working in good faith with ILS as required under Executive Law 832-4, yes. But if you're a county that is effectively working with ILS, acting in good faith under Executive Law 832-4, which right now I would say all the counties are, but that's true no matter what, right? That's true just because of Executive Law 832-4 and working with ILS. And I don't think these standards necessarily change that.
Okay, but so I think your point's well taken, but as you all know from doing the statewide implementation, you've got areas of the state geographically where it's just incredibly hard to find people that can do this work and that are qualified to do this work. So I'll just pick on, if you're Hamilton County and you're trying your best and you're working in good faith with ILS, but you can't do any of this, what kind of a position does that put Hamilton County?
Yeah. You know, I mean, they're standards, they're not regulations. So, you know, I don't know that they would create, you know, a lawsuit necessarily. But, you know, I think that the value of having the standards so that the counties, we know where to go, sort of outweighs that risk, if there is that risk.
I completely agree with that. And I would in no way, shape, or form advocate that we can't move forward because there are some who are unable to move forward. I think it's important for us all to be cognizant of that. And as staff thinks about how you roll this out and implement it, just being cognizant of that and working with those counties that are really, even though they want to, are really not going to be able to do this. And then what can we do?
What about explicitly recognizing that in the sentence in the introduction? To say that there may be, you know, jurisdictions that cannot, you know, that are restrained and are not able to, but these are meant to be guidelines and aspirational, something like this.
Yeah.
And you need to make it a little bit stronger and say, you know, under executive law, they're obligated to support these and will continue to partner with ILS to do so. I don't want to give anybody a free pass. I'm
Yeah.
trying to be.
They're aspirational. in some way.
Yeah.
And maybe we need to be a little bit more explicit about the aspirational nature of the standard.
Well, and it could also, the board could approve them with a statement that recognizes that these standards are at this point aspirational and guidelines to which counties should work with ILS on implementation.
Yeah, that's great. Thank you.
Yeah.
And that's one of the reasons to adopt standards, instead of
Yes.
identify counties that where you need assistance in working towards these goals.
Best practices.
Yes.
Is it asking too much for attorneys or investigators in counties where they don't have the resources to encourage them to document the efforts they made to obtain the resources? Like in a particular case, you know, because best practices include documenting things.
Yeah. So we could draft a statement for the board that would accompany the issuance of these.
That probably makes sense.
Okay.
And I just want to add that having standards for investigators when some of us started out and we sometimes had investigators, and sometimes we didn't, and the investigators sometimes thought that they were law enforcement instead. This is a fantastic evolution of defense practices.
I couldn't agree more.
Former police officers often, yeah.
Yes.
Yeah.
That's what we have.
Yeah. And we have to sometimes argue with them.
We have to do lengthy applications to the trial judge. Already investigated. More often than not, they were gonna.
The judge wouldn't
the
approve.
judge would not approve it. You don't need the police have investigated this, you know.
I've heard that happen a lot in misdemeanor cases. Would it also happen in felony cases? Well, and you know, frankly, these standards will help those attorneys.
Yeah. Oh, that's.
Yeah, yeah.
So I don't know whether people think they're ready to approve the standards today or not. I wouldn't think that we would need a board vote on approval of the statement.
Yeah,
I think you have the gist of what the statement's going to say. And that doesn't apply for it. So my suggestion, if people are comfortable with the vote on the standards now, with the understanding that there's going to be a statement that is along the lines of what Chris. Great.
yeah.
I'll make that motion.
All in favor? Opposed? All right. We're done.
It's very exciting. And what you said, Vince, like, we're already like, I want to get this played. I want to.
Right, exactly.
Sure, yeah. Sorry.
Okay. Sunday.
Yeah, thank you. Well, I'll run down a few items here. First of all, some new hires to announce for the board. Tim Clark joined us as an auditor back in June. Ying Lonergan Liu joined us as an assistant grants manager with our grants unit back in July. And Quell Horton Pham joined as a contract manager in July as well with our grants unit. I do want to just go on a very quick side tangent here to note that these are all three newly created positions for ILS. And that's notable in that we are expanding our grants unit, which was much needed to help assist with the volume of funding and contracts that we disperse. But I do want to pause here just to underscore our interest in exploring the option of creating the two new positions that I discussed earlier via that budget transfer, which would allow us to start creating these positions sooner. These three new grants unit positions that we filled in June and July of this year were proposed to the ILS board in our budget request in September 2023. Funding, the budget was passed in April of 2024. Then the process of going through the Civil Service Commission to create the positions, post the positions, recruit, interview, and then once we had made offers, have people go through the often protracted budget director approval process to get them on board took almost 2 years. Wow. So that anytime we are creating a new position via new funding in a state budget, that's the timeline that we have to work with, and that's with us going as quickly as we can to try to get, those positions filled. So just wanted to add a little context to our request this year. Other new hires, Kimberly Dubray joined us as a criminal defense representation resource support and data specialist, which is tied, or no, it's close to our longest job title. But I'm actually going to shout out Alan McReynolds in our Western New York Regional Support Center, who was promoted to senior resource support and data specialist. So we are very happy to have Kimberly on board and recognizing Alan's promotion. We were also joined just this week. Kevin Roman started in our Western New York Regional Support Center as our Family Court Representation Counsel out there in Buffalo. And on September 29th, we will be joined by Margaret Phillips, who is our new attorney in charge of the Western New York Regional Support Center. So we just set her start date. We're very excited to have Margaret on board. We are currently in the process of interviewing for 2 positions, both with our research team. One is for an administrative assistant position. The other is for a student intern, a graduate intern position. We are also currently recruiting for several positions: an Albany-based family court representation counsel. That application period is open through October 16th. We are soon going to be posting for an organizational development specialist. That is a position that was newly created as of this year's budget. And we also have a vacancy in our criminal defense representation counsel for Region G, which is another Buffalo-based position. We had posted for that. It remains vacant. We will likely post again to see if we can recruit candidates for that position. I also want to note that we have open RFP right now. So this is a request for proposal that we have open for up to 4 upstate model family representation office grants. So these are grants that can be used for family court representation. They are 3-year contracts totaling $3 million. So $1 million per year for counties to bolster their family court representation, public defense. And that RFP closes on October 20th. So we are hoping that we will see several applications come in for that grant that will then go through our RFP scoring process, and we'll hopefully have contracts in place as soon as we can to the start of the new year. Those are the updates.
Questions? Great. I think we're done.
Wow.
Great. Adjourn the meeting. Thank you all.
Thank you.